Good morning, everybody. Great to see so many people here this morning. I can certainly appreciate the fact that a lot of us might be kind of zoomed out a year into this, so it's sensational to see such great participation from everybody, and we certainly thank you for that. Before we get started, guys, I just want to let everybody know, I'm sure there'll be some questions throughout Lindsay's presentation. We're going to do things slightly differently this morning. Rather than saving all of the Q&A till the end portion, we're actually going to split it up into two. So at the end of the second section, there'll be 3 sections total in Lindsay's presentation. We're going to open up the floor at the end of the second section. So if you do have any questions, please be sure to, of course, write them in the Q&A, and we'll address them at the end of the second section. And then we'll open it up a second time at the end of the third section if there's any further questions. If that's okay with everybody, so keep that in mind, and we'll certainly get those questions addressed. That said, I certainly want to thank our sponsor for this morning's webinar, which is, of course, Hancock and Macarthur. Very generous, of course. And if we're okay to get started, I'll tell you everybody a little bit about Lindsay, who's a brand new member of the WHBA. Now, Lindsay Reynolds is an accomplished Gold Seal certified project manager and certified construction adjudicator based in Burlington, Ontario. Her 15 years of industry experience and impressive knowledge of construction projects is the foundation on which she built Hancock and Macarthur, an owner's representation and construction project management firm, in 2019. Lindsay was introduced to the construction industry while studying civil engineering at the University of Waterloo, where she landed a co-op assignment with a local soil testing company. She first stepped onto a construction site, and when she first stepped onto a construction site, she instantly fell in love. Upon earning her degree, Lindsay quickly established a career in construction management at PCL Construction, where she developed a reputation for excellence and leadership in various roles, including estimating, pre-construction services and project management. Lindsay continued to develop her expertise as project manager and director of operations at Reed's Heritage Construction and senior project manager for Starlight Investments. As president and principal project manager at Hancock and Macarthur, Lindsay offers a broad range of expertise in residential construction management, from conception to closing. From high-rise construction budgeting to managing design development on behalf of the owner, the communicating project progress and milestones in occupied buildings, she has done it all. With a high-level insight and sharp eye for detail and exceptional communication, Lindsay can proficiently navigate the unique intricacies of each project and facilitate successful outcomes for all involved. In 2020, Lindsay became a certified construction adjudicator under the new Ontario Construction Act, an accreditation which she pursued owing to her passion for the construction industry and ethical philosophy. Whether she is on site, coordinating suppliers, negotiating contracts, leading progress meetings, or developing schedules, Lindsay's love for the exciting and dynamic industry of construction only continues to grow. Now, that said, we'll certainly turn it over to our host of this morning's webinar, Ms. Lindsay Reynolds.
Thank you, John Anthony. That was very generous and greatly appreciated. And I feel like I'm going to have to get my bio rewritten so that it can be like a movie trailer, in a world when, and then I'm going to get you to voice it for me. Good morning, everybody. And thank you for joining us at this early hour on a Monday for something that sounds as tantalizing as prompt payment and interim adjudication. I brought this, I created this, sorry, we'll move on to the next slide. Okay. So my name is Lindsay Reynolds, as John Anthony said. I am a registered construction adjudicator in the province of Ontario, and I am also the founding president and principal project manager at Hancock and Macarthur. John Anthony pretty much covered it, but Hancock and Macarthur, we are new here at the West End Home Builders Association, and we're so glad to be a part of this group. So far, we've been hanging out at some of the Coffee for the Win and some of the other events, and I'm just already so impressed with the organization and the professionalism, but always maintaining a sense of fun. Even virtually, I can tell that this is a really great group of people, and I'm very, very personally attracted to this culture. I can't wait to get out in person and really start to meet you all. As John Anthony said, Hancock and Macarthur is a construction management business founded on my passion for the construction industry and my desire to see businesses and organizations see more success in their construction projects, whether it's just a one-off for a company that needs a new office space, or it's a developer or a home builder who needs to take it up a notch and build more sophistication into their construction projects. We are here for you. So without further ado, I'd love to get into this prompt payment and construction adjudication topic. So prompt payment and construction adjudication and the Ontario Construction Act is a big subject. I mean, this is something that really requires probably several webinars and discussions. It's going to take us, as the construction sector and the industry, it's going to take us a few years really to work it out and understand all of it very well. So this webinar is really just going to be a scratch the surface webinar that hopefully achieves two key purposes. And the first is just generally to increase knowledge and awareness. It would be a success for me if some of you came to this webinar not knowing anything about this new act and just had a few more things that you could go out into the world and start Googling and asking questions about and understanding, gaining further understanding about how this works for you and works for our construction sector. And also to promote discussions within the industry, because this is going to be a working out. The Ontario Construction Act is brand new legislation, and brand new legislation in our legal environment requires a working out, it requires discussion, and it requires use. A lot of these things that we are going to talk about today have yet to see the courts. So there haven't been any court decisions on some of the gray areas, and so this is going to be something that evolves quite a bit over time. We're going to all have to interact with it and see how it plays out. But I want to start you with an introduction to the most interesting things that are in there. So the agenda, we'll start with a brief overview of the Ontario Construction Act. Super brief because it's a big piece of legislation. Then I want to dive into more of the details around the prompt payment legislation portion of the act. And then we'll get into, and after this prompt payment legislation, that's where I feel like we'll be ready to take a little bit of a break, and we'll see if anybody has some questions that that we can answer, that I can talk around at that point in time. Then we'll jump into interim adjudications and what that means and how that supports the prompt payment portion of the legislation, and what else, other opportunities it gives us in the construction sector. And then a little bit about adjudicators, which is a new role that exists under the Act, and what that means if I'm a certified construction adjudicator. What does that even mean, and what does that mean for the others that you might find out there? And then we'll have all of the Q&A, and I'd like to spend as much time as possible in Q&A because, like I said, as a surface scratching webinar and discussion, I'm sure that there are some things that are going to come up for you as you're listening. And if we're going to dive down into the details anywhere, I want it to be the details that you're actually thinking about and that you're really interested in. And I find that we can do that most effectively in the Q&A portions. So the Ontario Construction Act. If you weren't aware, the Ontario Construction Act is, like I said, a brand new piece of legislation. It was previously called the Ontario Lien Act, and the Ontario Construction Act came out in two portions. The first portion, which just changed some of the lien legislation components, came into effect in July of 2018. And then the whole rest of the act came into effect on October 1st of 2019. And by come into effect, that means that any contracts or agreements that were entered into after October 1st of 2019 now fall under all of the legislation within the act. If you want to dive in after this and really get into the nitty-gritty of it, the full act and regulations are available online at ontario.ca/laws. The whole link is there. I'm very happy to make these slides available to anybody who would like them after this presentation. So all of these links can be clickable and you'd be able to follow them yourself. This seems intimidating to you to go in and read the legislation. If you are familiar at all with the Green Book and reading the Ontario's Health and Safety Act, this basically reads the same way. So if you can read the Green Book, then you can access this information firsthand for yourself here on Ontario's website. 3 key points about the Ontario Construction Act. This is the surface of the surface of the surface. First, it replaces the Lien Act. So everything that you know, if you were aware of the Lien Act before and everything in it about 10% holdback and 45-day periods for protecting and perfecting your lien rights, that has been completely replaced. And there are new durations for lien perfection and preservation, which are a little bit bigger than 45. We really don't have time to get into it here. I'm happy to answer questions if you have any, but that is a couple other webinars all in and of itself. The second is that it includes this prompt payment legislation, and that means that prompt payment under construction contracts, under payments for services provided that fall under the Construction Act, are now, payment terms are now determined by the Construction Act. And there's more detail to it, but the quick and dirty is that an owner needs to pay a contractor in 28 days after receiving a proper invoice. That's what prompt payment mostly means under this act. And then as a partner to the prompt payment legislation, it also includes this interim adjudication as an alternate dispute resolution process. Interim adjudication is meant to work hand in hand with prompt payment and make it possible and give it a full package, but it also works as an alternate dispute resolution for a number of other things on construction projects. So, prompt payment. This one is such an exciting topic. Prompt payment, now the idea is to get money flowing in the construction industry a lot faster than it has been in the past. And the challenge with the construction industry is that it operates on this construction pyramid where no one really gets paid. If you're really, really far down the construction pyramid, you're usually a pretty small operation and you usually get paid last. And prompt payment is really trying to equal that out and keep the construction sector healthy and financially viable. So this is how it works. First of all, prompt payment is outlined in the Act. I'll point you to it. It's outlined in Part I.1 of the Act. So if you followed that link I showed you before and you're following along, this is where you'll find it. It's very exciting. Hopefully I can make it a little bit more interesting than reading it. It's part of the objective here. And prompt payment involves 3 key components: proper invoices, a notice of non-payment, and then specific payment timelines. So the payment timelines, the 28-day payment terms that I was talking about before, that depends on this very first defined piece called a proper invoice. Proper invoice is now outlined in the Act itself. It's actually in the legislation. It is defined in section 6.1 and 6.3 of the Act. So this isn't advice that I'm giving you on how to interpret the Act. I'm really just trying to kind of read it to you in layman's terms. All of these things that I'm telling you about actually exist in the Act. So it is now legislated that a proper invoice in an agreement that falls under the Act contains 7 things, 6 really specific things. They are the name and address of the contractor, the date of invoice and period of supply, the contract or PO number, the description of services or materials, including quantity, the amount payable, and the name and contact information of for payment receipt. So none of these things are especially mind-blowing. The interesting thing here is, first, that this is listed in the legislation. So that's the interesting thing. The rest of it is really just, I think that if you had gone to any of you are business owners and you were sort of setting up your first invoices and your accounting system, these are all of the things that your accountant would have advised as best practice for invoicing. So there's nothing mind-blowing about this at all. This is actually just good accounting. Now it's legislated and it's required to start that time from day 1 to day 28 when the payment is due. There's one more thing on the list, and that is this number 7, any other information that may be prescribed. So on one hand, it's very tightly defined, and on the other hand, it's cracked wide open. So I want to take a second and talk about this idea of any other information that may be prescribed to have on the invoice. What does this practically mean for owners of projects, for contractors and suppliers and service providers on projects? This means that there is a component to this prompt payment process that needs to be considered at the time of purchase of product or service. So in a PO, in a contract, the owner needs to think about, what is it that I also need in this invoicing system, in this payment system, to be able to practically process invoices in 28 days. There may be any kind of thing, like you need an additional piece of information. You need to have an invoice in advance. It gets a little awkward, and we're going to find out why in a second, because this isn't for anything. This is just for a few things, and there's some qualifications later. The other side of this, so the owner has to think about this when they're buying services. The contractor, the supplier, service provider, what this means for you is that you need to carefully read your contracts and your POs and look for any information, any requirements in there that you need to add to your invoicing system to make sure that you're providing your clients with proper invoice. A best practice here really is to talk about it. So when you start up a project, when you start up a service provider with a service provider, have a bit of a kickoff meeting, discuss this process and what the intent and everything is behind it, and anything in there that might fall under item number 7, that is any other information that's required. So it's not anything, because there are some items that are not allowed to define a proper invoice. And those items are written in the legislation, and they include prior certification by a payment certifier. So this is a fun one that's going to take some thinking and some effort and some administration, probably on most of the owner's parts, because this does not mean that payment certification is no longer going to be a part of how we finance projects. Payment certification, I'm 100% confident, is still going to be required by a lot of financial institutions and other sorts of business entities when it comes to the commercial terms and getting money flowing. That's not going away, and it has nothing to do with this part of it. The problem is that now payment certification and actual payment of invoices is going to happen in parallel. Payment certification cannot cut off or stop the flow of money under the prompt payment legislation. The second thing is this idea of owner's approval. So anything that is like the owner is going to take the invoice, it has everything on it, but they just want the chance to be able to review it and approve it, that is not a part of the definition of a proper invoice. There is another mechanism for if an owner disagrees with the amount of an invoice, there's a mechanism for that. It's not on this list of proper invoice definition items. And specifically cannot be included as a requirement. And then the last thing that is important to note, it doesn't happen a lot, or hasn't happened a lot in my experience, but I'm sure it happens from time to time. Invoicing work must happen no longer than monthly. I struggle with the grammar around how to sort of say that, but if a supplier or a contractor or a service provider is continuing to work on a project and the timeline is longer than a month, then the invoices must come no further apart than monthly, and be processed on this 28-day timeline. They can happen more frequently, but no further apart than monthly. Quarterly billing, if work is ongoing, is not allowed in the legislation. Sorry, so I made a note about the owner's approval. So this is the piece where the owner's approval can come in, and it's called a notice of non-payment. So let's use an example, because this is getting to be a lot of information sort of floating out there in a cloud. Let's imagine there's a home builder, and they've got a row of townhouses that they're building, and they've hired a plumber. So the plumber and the owner have a contract. It falls under the act. The plumber understands how to prepare a proper invoice, and they're doing it on a regular basis, and they're getting paid. And then one month, the plumber comes in and they submit their invoice, and everything on it is proper and fine, but the owner disagrees with the value that they are invoicing. They think that the plumber is asking for too much money. What is the option that the owner has to not pay or to respond to this invoice if they're not allowed to have owner's approval on as a definition of proper invoice? This is the mechanism, and it's called notice of non-payment. It is a form that is available on the internet under Ontario court forms. It is fairly simple. It's unusual to have all of these forms and paperwork in this process, I know, to date, but these all exist there for your use, and they're highly recommended because they capture all of the information that you would need to be able to do this effectively. So as the owner, you disagree, you pull up this form, and all you really need to provide as far as information on here is your name and address, the description of the premises where the work is being done, the name of the contractor, their address, the address for the services, wherever that is happening, and then a note about which invoice is actually under dispute, just providing the date. And then the owner has an option to say they're in dispute of the full amount of the invoice, or they are in dispute of a portion of the invoice. They would fill that number in here. And then there's a bit to provide reasons, and reasons are super important because they then feed the rest of the process that we'll talk about in a minute, which is the construction adjudication piece. So filling out this form with as much information as possible is highly recommended. And then this forms the notice of non-payment. So this is what the timeline looks like. Day 1, a proper invoice is received. By day 14, the notice of non-payment is due. So this is, if the owner gets the invoice and they respond with a notice of non-payment between day 1 and day 13, 14, that's what's expected. If the notice of non-payment is not issued until day 15, then it's not really technically valid under the legislation at the moment. Day 13, day 14 for a notice of non-payment, no problem. Day 15 is too late. And then is our day 28. Day 28 is the day that the payment is due to the contractor. On day 28, if there is a notice of non-payment and there's an amount that's in dispute, and there's a notice for it, then the amount due to the contractor is still anything that's not included in the notice of non-payment. So the notice of non-payment doesn't stop the 28-day timeline. It just takes a portion of funds out of that payment requirement to say this bit is in dispute, so we're not paying it. Everything that's not in dispute, money still needs to flow on day 28. And then after the contractor, down the pyramid come their subcontractors whose payment is due 7 days after that on day 35. And then there's subcontractors on day 42. And 7 days after that, all the way down the construction pyramid. Those are the legislated timelines for payment terms under the prompt payment legislation. This is the point when I wanted to take a breath and open the floor up for questions, and just see how we're all doing here. If we were able to do this in person, I'd be able to read the room. That's not physically possible. So I'd love to hear from you if you are starting to formulate some questions.
Feel free, guys, to just post your questions in either the chat or the Q&A section. I know Lindsay's been doing a great job so far informing us all, but certainly if anyone has questions, now would be a great time to bring them forward.
There was a raised hand that I saw pop up. Oh. Danielle.
I'm not seeing any questions just yet. We'll give people maybe a minute or two. Lindsay, you might have done too good of a job so far. There's no questions just yet.
Well, at least I got a chance to take a sip of water. Oh, here we go. So Danielle has a question. How does this affect the rental industry? That's a great question because, and so that comes back to the overall definition of what falls into the act. So it's not just an owner and a contractor. I am using simple terms because I'm trying to keep the ideas around this very simple, but technically the relationship between a property owner and the person who, the supplier or contractor or service provider, it falls under the act if the service provider, constructor, or supplier is adding to the value of the property in some way. So in the rental industry, there is some work that you would do where you just have maintenance on your properties. So maintenance on properties is excluded because it's just maintaining the current value of the property. But if there's any increase in value, so if there's an upgrade on equipment, if there is renovations that are done, if there's any additional common area amenities or anything like that, all of that work constitutes an increase in value on that property, and then those contracts would all fall under this Ontario Construction Act and all of that legislation. Does that answer the question? There's a couple more too.
We have a question from Andrea. Was there not something that stated if an RFQ was presented prior to the October date, they would be grandfathered under the old act?
Ooh, so that's a super technical question, but it's a great one because whether a contract falls under the act or not, it really pivots on this October 1st, 2019 date. And work that was procured or negotiated or tendered before that date also may also be grandfathered and fall under the older versions of the act. That's a gray area that we are slowly working out of and not seeing as much of. But there's a chance that something in that gray area might fall under the act. And so there's no harm in, if whichever party you are, if there seems to be a benefit to you in this legislation, there's no harm in reaching out and trying to see if it applies, or vice versa, to see if it doesn't really apply to you yet.
Okay, we have a couple more questions starting to roll in. This is from Rachel Norman. I'm having a little trouble wording this. Does the invoice date and the received date have any effect on the prompt payment terms? How long after the invoice date can an invoice be received before the invoice date is not a valid starting point for the prompt payment timeline?
Yeah, so the key word here is received. So there needs to be an understanding in the contract as to what actually defines received. And that's probably one of those things that falls under the any other requirements where the owner, the contractor, the parties need to understand what constitutes received. If it's a particular email address, if it's a particular accounting software, if there's a location that the invoice needs to go to be defined as having been received. But it's received. So you can't put an invoice date of the 1st and then send it on the 5th and say, well, the 1st is the trigger date. It's the received date.
Okay, we've got a couple more questions starting to roll in. This is from Neil. Assuming that when assessing a monthly progress billing, a notice of non-payment would be required for each invoice within the billing package which are being disputed. Oh, I guess that's not really a question, is it? Well, Danielle has another question. Would that start on the day the service was issued? So a new water heater was installed on the 15th, thus the proper invoice would be issued on the 15th. Also, what happens if there are issues with the install? Can that be a reason to withhold payment with the non-payment notice?
So the invoice being received is a piece of paper changing hands, or virtual paper changing hands. So that's the key, is that the document is received. The actual date of the work is not as important as the date that the invoice was physically received. So I hope that that's clear. If there are issues, and so we'll jump into that in a second. I'm really glad that that this is starting to get you guys thinking, and we will have another Q&A session at the end. I want to definitely leave enough time for that, because we'll talk more about adjudication and how all that works. And hopefully maybe some of that answers some of your questions, and maybe some of that prompts a little bit more discussion holistically that we can talk about in a second. But I would say, yes, if you have a problem as an owner with the quality of the supply that you've received and you want to have some sort of holdback, that would be a reason. There'd be a reason why there's a portion of the invoice that you don't feel is appropriate. And so, yes, the notice of non-payment is a place to do that at this point. Mm-hmm.
Okay, another question from, or a question from Neil. Do we have to provide multiple notice of non-payment when disputing different invoices within the progress billing received from the CM?
That is a great question. And I feel like that has to do with the construction management contract type, where you are receiving invoices from your construction manager with all of the other invoices as backup. And depending on the type of contract, because there's a couple of ways to do construction management, if you have a construction management at risk where your contract is only with the construction manager, then you only need to issue one notice of non-payment. Your list of reasons might be long. You might need to back that up with something, but if it's, you only have one contract with the construction manager, so if it's a 5B, then just one notice of payment per invoice will do. If you have a 5A and you are receiving invoices independently from each of the trade contractors in that case, then you need to issue a notice of non-payment for each of those invoices from the trade contractors that there's a dispute about the amount. Not every single one just because there's one dispute, but every one that has a dispute on it. You're very welcome. Okay, I'm going to keep going, and then we'll do this again in another few minutes. So what do we do with we're going to go back to our really, really simple example just to keep things flowing of a plumber and our developer builder. So the plumber has just sent a proper invoice and received a notice of non-payment from the owner to say that their invoice is not going to get paid in full. The plumber will then only receive the amount on day 28 that's not in dispute. But the plumber does not actually agree that the notice of non-payment is valid. So what now? What does the plumber have as a resource to resolve this? And that's where we get into interim adjudications. Interim adjudications are supposed to be quick and cost-effective means of dispute resolution. They are, and when I say quick, I mean from the time that an adjudication is started to the time that any money flows out of the decision is maximum 60 days, really. There's other complicated, we could talk about this in 10 other webinars, but theoretically it's about 60 days max, which is shorter than some of the payment terms that exist out there in the previous regime. So this is what it looks like on a timeline for a construction adjudication. So the notice of adjudication would be issued by the claimant. In this case, it's our plumber. And our plumber would go on to the, as part of this adjudication process, there are construction adjudications. So there are construction adjudicators, and then there's this authorized nominating authority, and they are called ODAC. ODAC is just sort of the name for how they market themselves, but every time I talk about ODAC, they're sort of the authority that's overseeing this adjudication process, and that they are training and managing the roster of adjudicators to make these things happen. They also manage the website. So our plumber has gone on to the ODAC website, and they have started a notice of adjudication. And after that notice of adjudication, they have 4 days. They're the claimant. Now our developer, home builder will be the respondent. And between the plumber and the home builder, they have 4 days to choose their adjudicator. And they can choose anybody who's on the roster as long as they agree in 4 days. Then that's the adjudicator who will hear the facts of the case and make a decision. Now, from time to time, there are relationships where the parties can agree. So if 4 days pass and the home builder and the plumber cannot agree on who the adjudicator should be, then no problem. That's not a huge stall. ODAC, our authorized nominating authority, will appoint an adjudicator. There's a roster, there's a list, and they will just take the next appropriate adjudicator on that list and assign the adjudicator. And at that point in time, the adjudicator is appointed. And day one of the adjudication starts. So we have all of these timelines in the Act now that need to be followed. And that's what keeps things moving forward, is understanding what the legislative timelines are. Day one, the clock on the adjudication starts. This is how adjudications can look at the beginning. So prior to day one, we've got 4 to 7 days from the notice of adjudication to day one. Day one, the adjudicator is appointed, and on day 5, so less than a week, the claimant delivers their complaint. And a complaint basically looks like 2 or 3, maybe 10 pieces of paper, the contract, and a small amount of backup that is directly related to this particular single issue. And they will upload it to the website as their complaint. And then it will be visible to all parties. The respondent will then have 7 days to respond. And then there will be a process. Now, basically from day one all the way to the end is the adjudication process. And the adjudicator who has been appointed really gets to define this process. The day 5 and the day 12 are in the Act, not as strongly as the rest of the timelines, but that's generally the amount of time you can expect to put your paperwork together to be able to handle a dispute. So I don't know if you remember, but back when we were looking at the notice of non-payment, and we talked about the easy things to fill out, when it talked about the reasons at the bottom, I said that it's really important to fill out as much detail as possible, because when you get to this process, if you get to this process, that is going to be one of the key pieces of information that feeds the adjudication and helps the adjudicator come to a decision. The more information, the better the information that you can give the adjudicator. It's not going to be a lot. So it needs to be good, and you need to stay organized, because this process from day 1, day 5, and day 12 we're already running really, really quickly. The rest of the process defined by the adjudicator leads into day 30. So less than a month, the adjudicator has to gather all the facts, give everybody a reasonable amount of time to share their point of view, then they need to process all that information, discern the facts, identify their reasons and their position, and issue a decision. And their decision would then be sent to ODAC. ODAC takes 5 days really to take a look at it, just make sure that they'll review it for grammar, for other sorts of minor things, and they'll provide some feedback to the adjudicator, but the adjudicator has full responsibility for the whole thing. So if the adjudicator takes the feedback from ODAC and decides not to incorporate it into their decision, that's completely up to them. On day 35, the decision is released. An order is also written by the adjudicator and filed in the court. And then that order needs to be processed, especially if there's any funds that are ordered to be paid one way or the other. Those funds are due in 10 days. So from the date of the notice of adjudication to the date that the funds would flow. So if our plumber actually, maybe the owner kind of pushed back a little too hard and maybe didn't, and maybe refused to pay a little more, and the adjudicator looked at the whole thing and said, okay, well, maybe not everything is owed to the plumber, but some of it is owed to the plumber, and they make a decision and they say, you held back $10,000 from the plumber's invoice, and it really only should have been maybe $5,000. I'm going to write an order that you owe them $5,000 on this invoice, and that $5,000 would be due on that day 45. That's 60 days from the notice of adjudication by the claimant. That's still, we can go back. It's easier when you can see it. I'm a visual person. I don't have this visually, but I think if you do the math on all of that, that's like 90 days paid on a disputed amount, which is, it's never been. 90 days is often the payment terms just on regular invoices. That's how quick these things are. Interim adjudication is, like I said, quick. But it is two very important things. So these are it sounds similar. Alternate dispute resolutions often include things like mediation and arbitration, which are just outside of the legislated system. And mediation in particular, I know you can agree to go into a mediation and you can get some help resolving your problems. Even if you come to a negotiated agreement through a mediation, they're not binding in any way. You can walk away and change your mind. The parties can change their mind and do whatever they like with that. Interim adjudication is not like that. Interim adjudication is interim binding and enforceable. So interim binding just means that an adjudication is binding until the parties, until a further determination on the matter, either in a court, an arbitration, or a written agreement between the parties, is issued. So the parties can go and they can take it to a different format and they can get a different decision made on it. But until they do, that decision is binding and it's enforceable. So it's enforceable under the Act. Like I said, there's a court order to pay. And if payment does not, if there is no payment, contractors actually have the right now under the Act to stop work until they're paid, which was not a right that they had before. And they also have, so they have the right to stop work. And sorry, I lost my train of thought one. It's enforceable. That's what you need to know. It's very important. Okay. Interim adjudication, what can be adjudicated? So in this example, the main reason why adjudication was added into the legislation was to support this prompt payment system. So that's its primary role, but it also acts as another option for dispute resolution. And because it's quick and it's cost effective, it can be a good way of managing longer construction projects that get a little bit hairy, and dealing with problems as they arise and trying to keep a clean slate. Here's a list of things in the Act that can be adjudicated. They're listed in section 13.5. And they are valuation of services, payments under the contract, including change orders, then our disputes of notice of non-payment, which we were just talking about, that's our main example here. And then everything around liens and holdbacks. So amounts of holdbacks retained, payments of holdbacks, non-payments of holdbacks. We're going to see this more and more. The adjudicators are going to see this more and more, I think, in the future, because a lot of the contracts that fall into this are not quite at the stage yet, but this falls in there. And then again, we have a number 7, any other matter that the parties may agree to or that may be prescribed. So this is something that can also be augmented within a contract, that the parties can agree beforehand that they're going to handle certain kinds of matters through adjudication, and they don't. It's not a it's pre-agreed, and you don't have to have one party saying I want to do this and the other party, getting all upset. Interim adjudication needs to be understood. Interim adjudication is a right. So this isn't like arbitration or mediation where one party says, I want to do this, and the other party can say, if it's not in the contract, the other party can say, I'm not interested or whatever. Interim adjudication, whether or not it's identified in the contract, is a right that both parties have, as long as the contract falls under the Act and that it's after October 1st of 2019. This is available to all parties. So quick and cost effective. How much does it cost? The fees for adjudication are primarily negotiated with the adjudicator. However, these are the rates that are posted on ODAC's website. So sometimes the parties cannot agree on a fee with the adjudicator, and ODAC has to set the fee. And if ODAC has to set the fee, this is the table that they use. So you get a sense for order of magnitude what these fees can look like. If there is a dispute, like our notice of non-payment, let's say it was $15,000 between our plumber and our owner. The adjudication fee for that $15,000 would be $1,000. And the fee, more often than not, it is expected and understood that the fee would be split between both parties regardless. Unless there was something malicious happening and the adjudicator decided that someone had started an adjudication just to cause trouble, they might make that party pay the entire fee. An adjudicator could do that, but in general, the expectation is that this fee is split 50-50. So if the plumber disagrees with the amount of the notice of non-project or notice of non-payment that is $15,000, and they go, you know what, even if I get $5,000 of it, that's good for me this month. It helps me with my cash flow. It's worth $500 to get that money. It's certainly more cost effective than going to court. The other side of it, though, is that you have to understand that your adjudicator is getting paid this fee. So adjudicators only get half of the fee that's getting paid. In this example, the adjudicator would get a $500 fee, half of the $1,000 fee. The other half goes to the nominating authority for administrative purposes. So the adjudicator on $500 fee is likely going to spend 2 to 3, maybe 4 hours on this particular issue. They're not going to read a lot of paper. They're not going to be interested in all of the file structure that exists and all of the backup. They want to see a couple pieces of paper that's explaining what the issue is. They're going to read it. They're going to discern what the issue is, and they're going to make a decision. It's going to be fast. So let me just talk quickly about adjudicators. Who can be an adjudicator? Adjudicators are not necessarily lawyers. Adjudicators are construction professionals. So the requirement is that adjudicators have a minimum of 10 years of experience as construction project managers, quantity surveyors, engineers, architects, accountants, and lawyers and arbitrators. But you have to understand that an adjudicator is coming to the table as a construction professional. They are resolving and making dispute decisions based on their construction experience. They are not necessarily giving you legal advice of any kind or coming to the table as a traditional judge. They're a construction adjudicator, which is this very specific thing. They are trained through ODAC, and there's an application process, and ODAC approves them and adds them to the registry. There is an expectation of neutrality. So I've had the question before, can we have an adjudicator in-house? Can we just hire somebody to be our adjudicator? And yes, you could have somebody who is an adjudicator on your payroll, but they will not be able to adjudicate anything involving you, because that would be a conflict of interest. So they could adjudicate anything else, and they could do adjudications on the side, but you can't hire an adjudicator in-house to be yours. That would be an inherent conflict of interest. There are certain ethical requirements, like adjudicators have to sign off that they're not an undisclosed bankrupt, or that there are any criminal record or any of those things. And then it's really important that adjudicators are clear communicators. It's a very important part of the job that adjudicators are able to read and discern and then communicate the facts of the case, the reasons for their decision, and clearly articulate their decision so that the parties understand why the adjudication was concluded the way that it was. What can an adjudicator do? So adjudicators have very broad, a very broad net of things that they are able to do. There's not, it's listed all in section 13.12. But they can, so first of all, they're primarily responsible for the adjudication process. So they define the whole process and decide exactly how it goes. The parties can make suggestions as to how they want to run things, but the adjudicator gets the final say. They ascertain the relevant facts and law. They can draw inferences. So just because something's not explicitly said in there, the adjudicator can kind of put it all together to make a decision. They can conduct on-site inspections and obtain third-party assistance. This is really only for very, very large ones. It doesn't make any sense to have these services on a smaller job like we were talking about with our plumber. There just isn't enough time. And they can make a determination. They are supposed to make the determination. And then they may have any other power that may be prescribed within the contract. So that is something else to think about when you're coming to your agreements and when you're reading your contracts. How do you find an adjudicator? Like I said before, there is an adjudicator registry on odac.ca. Something important to understand about adjudicators is that the certification expires after 1 year. So if you have been party to an adjudication and your adjudicator, you liked the adjudicator, they did a great job, they were fair and reasonable, and it all worked out, and you come to another adjudication in the future and you are, want to use them again, you need to still go through ODAC and find them on the registry and make sure that they are still certified. Because if they are not on the registry, even if they've adjudicated in the past, they are not allowed to adjudicate in the future unless only adjudicators on the registry can perform construction adjudications. And that was scratching the surface. Questions?
We do have a couple questions here, Lindsay. The first one I'm going to field, if that's okay with you. This was a question that came directly to me. The question is John Anthony wearing pants? Now, that's a silly question. Obviously, I am not. So let's keep it relevant. Now, the first question. Sorry.
Recorded for posterity.
Yeah, now, the first, our first actual question, it comes from Henry de Jong. If a check is mailed on day 28, does that count as paid on time, or does it have to be received by the contractor by day 28?
So obviously, I'm sure all of you know from your experience in the industry that all of these things can run fairly smoothly with a little bit of positive relationship and good communication. It's highly unlikely, if you have a good relationship, that a couple of days on payment here or there is going to be a big problem. If you don't have such a great relationship and things are getting really contentious, then it's possible that the payee of that check might get really upset that it's not getting, it's not been paid on day 28. They didn't receive the money and were able to deposit it on day 28. I'm sure that that's something that can be worked out with a good relationship. It is something to be aware of, and I think it actually feeds back, and the question behind the question is how, as an owner, how do I as a payer of invoices, manage my administration so that I can even hit these timelines? They are very tight. It's one of those things that'll have to be worked out. It's an answer, non-answer.
Fair enough. Another question from Eric Reisman, apologies if I mispronounced that, Eric. Now, what happens when payment has been submitted to a sub for a completed item, but then an issue later develops, but payment has already been submitted? Can owners submit notice of non-payment or other unrelated invoices?
I'm sure you could try using a notice of non-payment on a future invoice to identify an amount in a deficiency or anything that you wanted to hold back as a reason to not pay the full invoice. The other option is to use the adjudication process because if you saw on the list, it's not just about adjudicating notices of non-payment. You can also adjudicate the valuation of the work and adjudicating other things outside of this payment process. So if something came up and you didn't want to just follow through the payment process to get your chance to say, I don't agree, jump right into an adjudication without the payment process and say, there's a deficiency valuation that I've overpaid for and I want my money back.
Excellent. We have another question from Christine Buffery. Is there anything in the definition of proper invoice that requires the work to be completed prior to invoicing? What stops a trade from invoicing before the work is complete to start the 28-day payment timeline?
I would say there are a couple of mechanisms that can work for that. One of them is some clear definition under using item number 7 to provide some clear definition to what is allowed to be invoiced for. I mean, it's very common practice to receive invoices on, say, the 25th of the month for work that's expected to be completed all the way to the 30th. And that's really, really common and really not a problem. And if that's your agreement, then you can continue to follow through with that. But if there is some sort of reason why it works, the whole thing works better, or you really want the work to be completed before you see the invoice, then I would say make sure that that's clear in your agreement at the beginning. And then the other mechanism is the notice of non-payment. So you get an invoice and the work's not complete. You could use the notice of non-payment on the whole invoice to say, thank you for submitting your invoice, but you haven't completed any of the work that you've invoiced for. So we're not paying any of it.
Great. Okay. We have an additional question from U40 Chair Dan Guest. If you don't receive a notice of non-payment, when can you start the adjudication process if you suspect there's going to be an issue with payment?
Day 29. So it would probably not be in your best interest to start it on day 27, just because you're really confident that the check's not coming tomorrow. But day 29, you can absolutely start a notice of adjudication to say, and keep in mind too that these things work out practically. So you start a notice of adjudication, and it's entirely possible that you post that notice of adjudication and you get paid 2 days later, because your client goes, oh no, sorry, we just forgot, or oh, you're serious about this, and you don't even go through the adjudication process. So that would be the mechanism that exists that's intended to be the most helpful for that. I hope that answers the question.
Did I say adjudication? I think I forgot a vowel there.
It's a fun word. I say it a lot just because it's fun to say. Adjudication.
Okay. Is there any other questions, guys? It's great to see so many really engaging questions. Obviously, Lindsay's done a great job with this presentation. Do we have anything further beyond the great questions that have been asked, put forward already?
So I do want to say, just quickly, in the slides, this is my Q&A slide, but I have a list of additional resources. If you really want to geek out on this, there's some some deep dives in here, but then there's also like a podcast from a web, a lawyer's office on their experience of actually supporting a client through an adjudication. That gives some insight, and some other articles. Some are easier reads than others, but certainly all of that. And then all of my contact information is in the slides as well. So I'm happy to field future questions at any time that you think of them.
Okay, okay, we have another question from Danielle. Let's say there is an agreement with a contractor and a rental provider for a new build. Payment is organized so that the rental provider pays the total amount to the contractor, and the contractor will pay the builder, but they are not in the initial agreement. If the contractor does not pay the builder, but they received the full payment, can that be taken back to the rental provider?
So I'm reading it as well, trying to follow.
Yeah, no.
The contractor does not pay the builder. So we're dealing with a situation where there's it's like a pyramid of, there's an owner type person, then there's a contractor, and then there's another payee at the bottom of the pyramid. Okay, so some of this starts diving into a space that gets really like legal, and you do need to start talking to lawyers at some point in time in this process. And sometimes like this, by the way, this process does not exclude lawyers or the courts or anything like that. There's still necessary participants in all of this. I'm not quite wrapping my head around the question. I would be very happy, Danielle, if you want to reach out to me afterwards, I'd be happy to chat with you, phone call or email or anything like that in the future. I think this might be actually a breach of trust issue, which is something that's totally different. And like I said, you really want to get a lawyer involved, but I'm not entirely sure. Happy to talk about it.
Okay, a couple more questions popped up. The first from Heather Gordon. Is the presentation available? She had some problems linking up.
I'm happy to make everything of mine available. Like I said, distributing the slides to everyone is my pleasure. And then everything else, I believe, is on the WeHBA servers. So leave that with you guys.
We have another question. What is the payment certifier's role in terms of the contractor issuing their invoice for the 28-day period?
Yeah, they don't have one. Yeah, it's very challenging, and that bit about payment certification is going to have to be thought out between the payment certifier and the owner and probably the financial institution as an administrative plan before getting into this, because the payment certification is not a reason to delay or stop the payment timeline. It has to happen. It's going to happen, but it has to happen in parallel. It can't be part of that process or that timeline or interrupted in any way.
I think that's it with regards to questions. So on behalf of, we had a great attendance this morning. On behalf of the WeHBA, thank you everyone for joining us. Lindsay, of course, thank you for a very insightful presentation. I know the material in nature seems a little bit dry, but this is all very relevant information, and obviously our audience, thanks to their very engaging questions, you did a great job, and we're certainly very happy. Thank you again, everyone, for joining us. June 2nd, of course, we have our special AGM with a Dragon's Den panel. We have a great panel, plus myself, to be part of that. Keep your eyes peeled, of course, to your emails, our social media feeds, and our website for future webinars and future events. And of course, again, one more time, guys, thank you very much for joining us this morning.
Thank you.
Thank you, Lindsay.